So it's a project, actually a paper that Omri Ben Shachar and I co-authored, and it's about personalized negligence law. So as many of you, at least the lawyers among you, know, under negligence law, there is a standard of care, and the standard of care is uniform, right? It applies, right, to everyone, regardless of his capabilities. Now, there are some exceptions, like with minors. We know that there is a special standard of care for minors. And under some jurisdictions, also people who suffer from mental disability might also have some special standard of care tailored for them. And we also know that in some professions, like think about doctors, like compare a general doctor to an expert. Also, to the expert doctor, we would apply a higher standard of care than to the general doctor in the area of expertise, right? So there are some exceptions, but generally, the standard of care is uniform. So suppose, think about me as a driver and somebody else, like Tony. Tony might be much better driver than me, much more skillful, or maybe it's the other way around. Nevertheless, under the same conditions, both of us would be required by law to behave the same way, right? So if the conditions are the same, the standard of care would be the same for Tony and me, even if one of us is much more skillful than the other. Now, the argument of the paper is, this project is that personalizing negligence law could be quite a good idea from both efficiency perspective and also, so I am awaiting your question about democracy and efficiency, so also from other perspectives. So I'm going to focus on efficiency, but at Q&A, I would be very happy also to answer questions which are outside the scope of efficiency. So what does it mean, personalizing negligence law? It means that in my previous example, maybe Tony and I might have different standards of care, because maybe Tony is more or less skillful than me or had other capabilities that I don't have. Now, when we say that an injurer, it could be a driver, it could be a doctor, right, that could commit medical malpractice, and you could think of many other potential injurers. So when we think about injurers, sometimes we say those injurers are more harmful than others. What do we mean when we say they are more harmful? So if I asked you what would be your intuitive reaction? So suppose I tell you that there is an injurer who is more harmful. Does it mean that he should take more precautions or less precautions? Well, maybe the intuitive question would be probably more precautions, or maybe the other way around. But in fact, it's much more complicated. Why? Because when we say that an injurer is harmful, actually it could have like two different dimensions. One is skillfulness, and the other one is riskiness. What does it mean, skillfulness? So imagine a driver, and suppose that there is a certain new technology that the driver can use in his car and reduce risks. The driver might be very skillful in using this technology, or he might be less skillful. So this is about skillfulness. So also with doctors, there are some technologies that some doctors might be very skillful in using those technologies, some others could be less skillful. But there is another dimension, which is riskiness. Now riskiness, what we call riskiness, is the initial risk that a specific injurer creates even before taking any precautions. So think again about drivers. There could be some drivers with very good instincts, some others with bad instincts, right? So even regardless of precautions, some of them might be more risky than others. Now, maybe counterintuitively, if someone, an injurer, is more harmful in the sense that he is less skillful, what we argue, and I'll explain immediately why, that he should take less precautions. If instead the driver or the injurer is more harmful in the sense that he creates higher risks, he should take more precautions, right? So it goes in different directions. So if you are more harmful in the sense that you are less skillful, you should do less. If instead you are more harmful in the sense that you create higher initial risk, you should take higher precautions. And let me explain why. But before I explain why, I take it that most of you does not have background in loan economics. Certainly not in loan economics of tort law. So let me say just a few words about that because it's instrumental to what I'm going to explain in a minute. So under the economic analysis of tort law, under negligence law, what does it mean, negligence? Well, negligence under the efficiency rationale, so somebody is negligent when he could have taken precautions that would reduce risks by more than the precautions that he could have taken. So put it simply, generally what negligence law does, it requires an injurer to take precautions until the point when additional precautions would be more costly than risk reduction, right? So if at a certain point, precautions cost me $9 and it reduces risk by $10 and I don't take precautions, I am negligent. If instead precautions cost me $11 to reduce risk of 10 and I don't take precautions, I am not negligent. This is the efficiency of negligence law in like 2 sentences, right? Now, so what does it mean? So let's think now about the more skillful versus less skillful injurer. So imagine an injurer or 2 injurers that create an initial risk of $100. Initial risk of $100. One of them is more skillful. Now, what does it mean, more skillful? It means that he is more effective in reducing risks than the other one. Namely, that for $1 of precautions, he would reduce more risks, right? So back to my example of the driver using a new technology, if he is really skillful, the technology that he uses, right, would be really effective in reducing risks. If instead the driver is less skillful, maybe just waste of money if he used the technology because he wouldn't know what to do with it, right? So here is the first, I think, a bit counterintuitive argument. When the injurer is more skillful, he should take more precautions. When he is less skillful, he should take less precautions. Why? Because skillfulness means being more effective in risk reduction. So if you have someone who is really good in reducing risks, we want him to do more. If instead we have somebody else who is really bad in reducing risk, we don't want him to spend too many resources when it's useless, right, or less effective. Now, interestingly, it's exactly the opposite if it's about riskiness. So if I think now about 2 injurers, assume now that they are equally skillful, but one of them create an initial risk of 100, and the other one create an initial risk of 1,000. So 100 versus 1,000, same skillfulness. Now here, the intuition goes in this way, right? 2 injurers, one starts with 1,000, and the other one starts with 100. So what do you think would be, suppose each of them take $1 precautions? Well, this one, who starts with 1,000, probably would reduce more risks with the first dollar and also with the second dollar and so on and so forth, right? So if you start with 1,000 and the other one starts with 100 and they are equally skillful, we want the one who starts with 1,000 to do more just because he starts with much more risks, so therefore we will reduce more risks. Okay, so to summarize, harmfulness could be of 2 different types, skillfulness and riskiness. If you are more harmful because you are less skillful, you should do less. If you are more harmful because you are more risky, you should do more. Okay, that's the first point. Now the second point, okay, so let's assume that we personalize the standard of care to each and every injurer according to both risks and skillfulness, right? Suppose that's what we do. Again, I haven't discussed yet whether it's feasible or not. I'm going to talk about it, but for the moment, let's assume it is possible, right? It's possible to implement such a legal rule. Namely, it's possible to personalize negligence law. So the second question I want to discuss is what would happen to the injurer's incentives ex ante, namely investing in their skillfulness or their riskiness, namely what they would do under a personalized negligence law with respect to their skills. Let me explain what exactly the question and what the answer is. Start with skillfulness. Imagine an injurer. It could be a driver, a doctor, or any injurer that you can think of. Suppose he's unskillful. And suppose that now he considers whether to improve himself to be more skillful. Generally, we think that it might be a good idea. Well, not always, depending on the cost and benefits, but generally, on many occasions, we want injurers to improve their skills, right? But suppose you're the injurer and you think to yourself the following, under personalized negligence law. I'm less skillful, and therefore the standard of care for me is low. Remember, less skillful, the standard of care should be lower. So I'm under a low standard of care. That's what the law requires me to do. If I improve myself and become more skillful, the law would require from me to do more, actually to comply with a higher standard of care, and that might be too costly for me. So maybe I shouldn't improve my skillfulness. So this is a kind of a potential disadvantage of personalizing according to skills. If instead there is no personalized law, just a uniform standard of care, as we currently have, that would be different, right? If I know that this way or another, I am required to comply with a kind of a medium standard of care this way or another, and I can improve myself, I could be more skillful, I might have incentives to do it. Because if I do it, maybe precautions would be less costly for me. I wouldn't be required to take higher precautions, because with a uniform standard of care, this way or another, I am required to take a medium standard of care. So as you can see, with respect to personalizing negligence law with respect to skills, there is a disadvantage here. So the uniform standard provides incentives to people to improve their skills. Personalized law goes the other way around. Now with riskiness, it's the opposite. With riskiness, right, suppose now that there is an injurer that initially creates very high risk. And suppose he could improve himself or herself. It could be less risky. Now here, under personalized law, he would have incentives to do it, because if he is very risky, he is required, remind you, to take high level of precautions. If instead he would reduce his risks, he would become less risky, he would be required to take less precautions, so we have something to gain from improving himself with respect to risk. Under a uniform standards, it would be the opposite. Because under a uniform standards, the injurer would say, well, this way or another, I am required to take the same level of care, and therefore, even if I improve my riskiness vis-a-vis third parties, I'm not going to get any credit for that. This way or another, I would be required to behave exactly the same. Okay. Now, the third point I want to make, which I think it's, again, could be kind of counterintuitive. So suppose that we personalize the standard of care. So suppose that from now on, each driver would have to behave differently according to a different standard of care. How it would affect potential victims. So you are a pedestrian. At the moment, you can predict that all injurers would behave in the same way, right? All of them would drive 50 miles or 40 miles per hour, depending on the circumstances and so on, right? So you expect uniformity. Under our personalized negligence law, it might be different because Tony maybe would be able to drive 60 because he's a better driver, and maybe I would have to drive 40 because I might be a worse driver, or maybe the other way around. So every driver would have his own standard of care. And that seems to be quite problematic from the perspective of potential victims. How victims would adapt their behavior when each injurer behaves differently, and then actually it's very hard for them to predict what X or Y should do under certain circumstances. So this is true, that might be a disadvantage, but you can also think about it from a different perspective. And in fact, this is the argument, that once you personalize the standard of care, sometimes, although the level of care that people take might vary, there would be less variance in the risks that people create, right? So at the moment, think of this pedestrian that crossed the street, or if you drive your car, there are many potential injurers, other drivers on the road. Now, suppose that all of them drive exactly the same speed. So you think to yourself, well, this is uniform, everybody behaves the same, this is fine. But in fact, this is not fine. In fact, each of them creates completely different risk towards you. So what do you prefer? Do you prefer everyone to drive at the same speed? Some people, without your knowledge, might be very risky or very unskillful and create huge risk towards you. You don't know, but they create huge risk towards you, while others create lower risk. If you personalize the standard of care and you take risks into account, there would be less variances with respect to risks. So people generally would create similar risks toward you, and sometimes that might be an advantage. Do I have a few more minutes? Okay, so let me now say a few words about feasibility. So again, there are arguments against, and sometimes it's good, sometimes it's bad. Actually, the project is much more complicated. It shows that maybe you want to personalize. Sometimes it's better to personalize only skillfulness, sometimes only riskiness, but I won't go into it in this forum. Don't have enough time. So I want now to talk about feasibility. Suppose you are convinced that this is the right thing to go. Is it feasible? Is it possible? So it relates, of course, to some of the stuff that you have heard from the previous speakers, especially Tony. There is some correspondence between, I think, the two projects. But so how exactly courts would implement such a legal regime? So the simple answer is that they should have information about each and every injurer coming before them. Sometimes it would be direct information about the capabilities of this specific injurer, physical capabilities, mental capabilities, cognitive capabilities that might be sometimes checked by tests and so on and so forth. Sometimes they would look into past experience, past behavior, and of course would make use of big data, right? So big data might be a very important source of information to personalize the standard of care. Now, big data relating to the specific injurer, namely that on many occasions, even though we have not enough information about the specific driver as a driver, we might have information about him in other contexts. And what is interesting about big data is that you can sometimes learn from how people behave in different contexts to your context, right? So for example, you could know if the driver or the injurer is risk averse or risk lover, what about his mental cognitive limitations and so on. Sometimes you can learn from other behaviors and deduct all kinds of interesting conclusions that might affect the way in which the court should tailor the standard of care. But so actually there are two puzzles or two challenges here. The first one, whether courts would be really able to do it. Secondly, suppose they can do it, what about injurers? So suppose we are still not in the world of Tony, in which there is those, you sit in your car and get orders. Suppose we are not there yet. Well, this is a kind of, at the moment, at least a realistic assumption, right? We are still not there. So the question is whether an injurer would find it possible to live in a world in which he got a kind of a very complicated message. Says to him, drive in your car according to what is reasonable to you. Not to the reasonable person, not to the average person, but to you. So the intuition is that it would be very complicated, but in fact we argue that it might be the other way around. So think about yourself, right? Suppose you drive your car. It could be in Paris or in Tel Aviv or in Chicago or in any other place in the world. And suppose that you know that the law in that specific place tells you, drive your car as a reasonable person drives it. Does it really say something to you? It might say something. But what exactly you know about the average driver in Paris, in Chicago, or in Tel Aviv? I'm not sure that you know much about that. You could imagine. But if instead the law says to you, drive according to what is reasonable for you, according to your skills, according to your capabilities, according to your specific characteristics, that might be more informative to you. Right? Think about it of someone who is going to do a kind of a jogging. And suppose that suddenly he feels like a kind of a stress is in his chest, you know, he's feeling bad, and he has to decide whether to stop the jogging or continue. What do you think that person would ask herself? Would she ask herself what a reasonable person would do under those circumstances? Of course not. What he or she would ask herself is, what is reasonable for me to do under those circumstances? Because he or she, they know very well their limitations, their capabilities, and so on and so forth. And we think that it's not much different in many situations with injurers. They have much better information about themselves than anybody else. Now, the second and actually last question is, so what about courts? So would courts be able to personalize the standard of care and to tailor a standard of care for each and every one of us? So maybe one day they would be able to do so. At the moment, probably they could not. So what we argue that you could think of a kind of a midway between full personalization to no personalization at all. So think about it as a kind of a gradual personalization. Suppose that the law would be the following. The judge or the jury, depending on the legal system, should choose between low standard of care, medium standard of care, or high standard of care. So you could have 3 levels, or maybe 5 levels, 1 to 5. So that wouldn't be full personalization, but as we argue, it might be a dramatic improvement than what we have today. So even if the courts would only have to choose between low, medium, and high standard of care, it would be much better, at least from an efficiency perspective, but as maybe in the Q&A I would say something about other non-efficiency considerations, but it might be an improvement comparing to what we have today. Thank you.